Hello, this is a video lecture that is going to cover controversy number 7, should people have the choice to end their lives? And it will cover pages 265 to 295. So it's not a particularly long chapter, but this is a topic that is of uttermost importance for older adults. So Moody and Sasser begin the discussions on this topic by talking about depression. So I want to go over that for just a moment. The interesting and shocking statistic here is that while older people only comprise 14.5% of our overall population, they constitute 15.7% of all suicides. And the National Center for Mental Health has identified older adults as being at the highest risk for suicide, which I think is interesting because I think that we tend to believe that older or younger adults and even teenagers are more susceptible to suicide, but in fact it is older persons. Depression has a role to play in that, and depression is often not diagnosed in older adults. There are two types of depression. There's clinical depression and situational depression. Clinical depression is meeting at least 5 of the criteria that is used to diagnose somebody with clinical depression. Things like loss of appetite, inability to sleep, withdrawing from social engagement, having high levels of anxiety. If older adults are diagnosed with 5 or more of those conditions, they're considered to be clinically depressed. But there's another type of depression called situational depression, which is a kind of related to feeling somewhat down and could be as a result of a change, a life change, a loss. For example, somebody who just lost a loved one could have a situational depression, which is reflective of having gone through something recently that was very traumatic or created a lot of loss in their lives. So the estimates are that depression is less prevalent for older adults who are living in their own home. Depression goes up for those who are living in an institution. And depression also increases as people become more frail. So the increased level of frailty can produce higher levels of depression. So then the question comes into, if older adults experience this depression, whether it's situational or clinical depression, it brings about the question of competence. And are they capable of making decisions for themselves under the cloud of depression? So if you remember from the week 9 video lecture where we talked about some of the ethical considerations, such as confidentiality and autonomy and self-determination, we know that we cannot interfere with a person's ability to self-determine their own care. However, if we've determined that they are not competent to understand the consequences of those decisions, then it does raise some questions whether or not the person should be legally able to make decisions for themselves. So we have moving parts when it comes to decision making for older adults. There's the ethical considerations, there's their quality of life, there's their competence, their ability to understand. And in just a minute, we're going to be talking about that 4th component, which is advanced directives. So, but I want to talk about this issue of right to die. It really became a societal conversation back in 1985 with the case of a woman who was only 21 years of age by the name of Karen Ann Quinlan. And it propelled this issue of the right to end life. And under what circumstances is it acceptable to decide to end life? There are, I believe, 5 or 7 states in the United States that allow for self-determined death. It allows for people who are not under the cloud of depression and who are not considered to be incompetent. it allows for those people to make a decision to end their life. So there are different forms of the ways that decisions to end life can come about. The first is that an older person who is experiencing a chronic health problem, let's say they're having kidney failure, and they decide that the treatment for kidney failure is going on dialysis. And many people choose to forego dialysis. They choose to essentially end their life knowing that the lack of medical intervention is going to lead to death. That is not considered suicide. It is considered self-determining what they want in terms of treatment for healthcare. It would be the same example could be used for somebody who has, let's say, an aggressive form of cancer, let's say an 85-year-old who has breast cancer, just diagnosed with breast cancer, and decides she doesn't want to go through the grueling process of chemotherapy and radiation. And she may forego to have radiation and chemotherapy, knowing full well that that is going to end her life. So foregoing life-sustaining treatment is a decision that older adults can make and do make for themselves, as long as they understand the consequences of those decisions. The second type of decision is to terminate life-sustaining treatment, which was the case with Karen Ann Quinlan, a 21-year-old who ended up in an irreversible coma and who was being supported with a breathing machine and other mechanisms to essentially keep her alive. And the struggle came in with Karen Ann Quinlan about, should we pull the plug? Should the family have the right to end her life on her behalf? So you can read more about that case. It's on page 269 in your book. But terminating life-sustaining treatment is also legal and is not considered to be suicide. So, for example, let's take this kidney dialysis case. Let's say somebody did start on kidney dialysis and was doing that for, let's say, 2 years and decided she's done with it. It's a grueling process. It completely interferes with quality of life for some people. And people get to the point where they say, I don't want to do this anymore. So they are terminating life-sustaining treatment. Same with Karen Ann Quinlan. You can have an older adult who is on a tube feeding, who has no brain activity, but they're being fed by a tube. Should family be able to act on behalf of that patient and terminate life-sustaining treatment? So that's the second type of end-of-life decision. And the third type is assisted suicide. There are many states that permit older adults to make a conscious decision to end their life. People who are maybe not experiencing a life-threatening situation, but who simply decide, I'm done living. And they can seek assistance from a physician to end their life. Now, as you can well imagine, that is a controversy that has arguments, very solid arguments on both sides of the equation. One side of the equation is that we should allow for the relief of suffering. No older adult should be forced to suffer through the end of their life with low quality of life. Let's say somebody had a stroke and they are left completely paralyzed, but it's not life-threatening. They can still breathe, they can still eat, but they can't engage in any of the activities that they liked to do in the past. So some older adults then decide that their quality of life is simply no longer sustainable. or it's no longer achievable, and they decide that they want to end their lives. As I said, there's, I think, about 7 states in our nation that allow for assisted suicide. The other side of the coin is that there are physicians that believe that it's incompatible with their Hippocratic oath to help their patients, to cure their patients, to be beneficent and not cause harm to their patient, that physician-assisted suicide is in conflict with the Hippocratic oath. So I want you to read both sides of the argument in these chapters, and then I'm going to talk about advanced directives. So reading number 30 talks about physicians who support physician-assisted suicide. And then the other reading is, there's also reading 31 that also talks about physician-assisted suicide and is supportive of that. But then there's another one that is providing a contrary argument to physician-assisted suicide. And I cannot seem to find it at the moment, but I know that it's in this particular chapter. There is also, it's reading number 33, Why Doctors Must Not Kill. And I also want you to make sure that you read number 32, which is anti-story, because I believe that that is going to be a source of a discussion board for us this week. So let me get back to where I was with all of this. So we were talking about the 3 types of life-ending decisions: to forego treatment, to terminate treatment, and to seek physician-assisted suicide. So then, related to the ability to terminate life-sustaining treatment, oftentimes when it comes to a decision like that for an older adult, they are unable to make those decisions for themselves. So then those decisions need to be turned over to the family. And sometimes those can meet legal challenges. If you have a family, for example, that is in dispute with each other, and one thinks we should terminate the treatment for mom and another sibling or family member thinks that they shouldn't, how do those issues get resolved? Well, one way is that it can go to the court system, and a judge can declare a patient to be incompetent, unable to make their own decision, and can appoint a court-appointed family member or agent for the patient that is then has the legal right to make those decisions. That happens in cases where you have a bickering family, or maybe there's been a case of abuse, let's say financial abuse, and a particular family member wants to end the life of their loved one so that they can inherit the estate. So when these decisions are being made, they have to be made in the context of what is best for the patient and what would the patient have wanted for themselves, which is a legal term for substituted judgment, which is if I'm going to make a decision for my loved one, I need to make that decision. I need to make that decision on their behalf, and I'm making it as if they were the ones making the decision, not, well, this is what I want for her, but I'm making the decision because it's what she wanted for herself. So there are times when those issues of withdrawing life-sustaining treatment can reach a legal impasse because of quarreling families and whatnot. So the courts are available and would take into consideration a couple of things. It would take into consideration what would the patient have wanted, and what is, so basically substituted judgment, and the second is the best interest standard. Those are on page 269. Those are the 2 criteria that courts are going to apply to a case that is involving withdrawing life-sustaining treatment on an incompetent patient: substituted judgment and best interest. Now, one way that we can make this a little easier for everybody is for us to implement what's called an advance directive, which is the ability for a person to say, in the event that I'm unable to make healthcare decisions for myself, I appoint so-and-so to make those decisions. That's called a power of attorney for healthcare. So I am appointing somebody to make decisions on my behalf, and I have trust and confidence in that person. And I have discussed with that person what my wishes would be if I end up in a coma, if I end up having a massive stroke. Do I want to have aggressive treatment to rehabilitate myself? If I fall into a coma because I've had a diabetic episode, do I want to be revived from heart failure or respiratory failure? All of those decisions I can discuss with my agent so that he or she knows if that time comes that he or she can act on my behalf, what it would be considered to be my best interest and utilizing their substituted judgment for me. So that's a power of attorney for healthcare. There's also a living will, which is a document that states, under no circumstances do I want to be have my life artificially extended through ventilators, through artificial hydration and nutrition. So I can put into writing, I don't want to be kept alive on machines, is essentially what a living will is. And then the third advance directive is called POLST, P-O-L-S-T. It's Practitioner Order for Life-Sustaining Treatment. There is a POLST form that I put in your week 9 and 10 folder, and it's essentially a doctor's order, or it's a practitioner's order. So a doctor, a nurse practitioner, or a physician's assistant can sign this document, which covers a lot of different things. It covers, do I want to be resuscitated? Do I want to be put on artificial feeding? Do I want do I want any type of life-sustaining treatment? So it's actually an order. So it puts right out front there for the medical care staff an order from you and that is supported by your physician that gives the medical caregivers direction into what you want. So make sure that you take a look at that practitioner order for life-sustaining treatment form in your folder. Power of attorney, living will, and POLST are 3 advance directive documents that we can put into place now that will help to alleviate problems with making difficult decisions in the future. So I want to be sure that you're aware of that. Advance directives came really into being under the Patient Self-Determination Act. I think that was in 1990. That reinforced this idea that patients should be able to self-determine their own medical care, and they have a right to understand and have explained to them the consequences of making those decisions. But it suffices to say right now that our public opinion in this country is continuing to evolve into more favor regarding having greater choice for end-of-life decisions. Take a look at reading number 30 that talks about the factors that motivate people to seek physician-assisted suicide. The reasons people seek that is that they're having illness-related experiences, there's a threat to their sense of self, and they have fears about the future. So make sure that you take a look at that reading number 30. We've talked about elder abuse, and this topic also ties into the topic of elder abuse, as it does with the ethical decision making, because making a decision on behalf of somebody else for their health care could lead to an abusive situation. One that I had just mentioned a moment ago is financial exploitation. I want Grandpa gone so that I can inherit his estate. So we have to understand that in all situations with older adults, we always must be certain that the patient is not being subjected to an abusive situation. And the final comment I want to make about this is that decisions to forego life-sustaining treatment or to terminate life-sustaining treatment is not considered to be suicide. The end result is the same. The patient is going to die, but it's not considered suicide. It's considered a part of nature taking its course. And we know that death is a part of everybody's life course. So foregoing treatment is not equivalent to saying, I'm going to kill myself. I'm done living. It simply means I'm choosing to have the rest of my days that I have here on earth to maximize that quality of life than put myself through the rigorous treatment that would be involved in curing whatever I have. So make sure that you understand that point as well. That concludes week 10. The topic of should people have the choice to end their lives. Thank you and have a good week. Thanks.